Let's turn now to Jennifer Mascott, a former law clerk for Supreme Court Justice Clarence Thomas. She also clerked for Brett Kavanaugh when he was an appeals court judge, and she's now an assistant professor of law at George Mason University. Professor Mascott, thank you so much for joining us this morning. First up, look, the majority opinion decided that abortion was not explicitly protected in the Constitution and that it isn't a quote, deeply rooted tradition. But there are a lot of not just traditions, but also rights that Americans have become accustomed to. So after nearly 50 years of precedent, how is abortion and reproductive autonomy not considered a deeply rooted tradition here in America?
Well, as you've noted, yesterday was a very significant day at the court, but I think it's important to remember, too, the context that for the first 185 years after the Constitution was put into place and the Supreme Court was created, the court did not weigh in really at all on the important question of abortion. And so yesterday what the court really did was go back to that almost 200-year-long approach and tradition. It took itself out of the seat of power, recognizing that there are very deeply held views on both sides of this issue, that it's a very strong issue with lots of deep moral and social questions, and it's best handled by states, the Congress, elected officials, and local people being able to decide these important social and policy questions rather than the court developing a one-size-fits-all solution that it's trying to discern from a constitutional text that really doesn't address it.
I think Professor Mascott critics would push back and say the word she is also not included in the Constitution. Let me ask you, though, about Chief Justice John Roberts. He said that the court was going too far, that all it needed to do was uphold Mississippi's law. Mississippi itself, as you know, said that Roe did not need to be overturned. So why did the court feel the need to do that?
Well, quite frankly, I think yesterday's decision actually showed a quite amount of consensus really on the court, because in contrast to a lot of big decisions, there were not a lot of justices that chose to join only parts of the opinion. Chief Justice Roberts actually made the 6th vote in support of the judgment that the Mississippi law was constitutional. 5 justices were joined Justice Alito's opinion in full. And so the chief seems to be taking a slightly different approach. But even he recognized that to uphold Mississippi's law really was in tension with Roe and Casey. I think the majority opinion for Justice Alito noted and explained how the reasoning of Roe itself had been criticized from the beginning, even people who agree with the bottom line of the decision. The court itself has undermined the reasoning and the opinion consistently in different ways over the past 50 years. And so Justice Alito and the majority applied the stare decisis factors to Roe and found that here, because of the absence of workability, their view that it was egregiously wrong. And this deeply held views on both sides really made this an issue that was not for the court to impose a one-size-fits-all solution, but to leave to the states and people in Congress to look at. And I think in the long run, this decision will really do a lot to take politics out of the Supreme Court because issues of this level of importance really should not be decided for all of us by just 9 justices in robes.
All right, Jennifer Mascott, thank you so much for your time this morning.
Hey, thanks for watching our YouTube channel. Find your favorite recipes, celebrity interviews, uplifting stories, shop our favorite deals, and so much more with the Today app. Download it now.